The end-of-life decisions are one of the most controversial topics in medical practice. I would say these decisions and debates are mired by debates about their legality and morality in the modern day society, where good death engulfed life as something which is fancied by one and all. Steve Jobs, in a presentation ceremony at a Stanford University, he had said, "No one wants to die. Even people who want to go to heaven, they do not want to die to go there. And yet, death is a common destination that we all share." So let us try to look at the current scenario about the end-of-life decisions. The euthanasia journey in India began with the Arun Sharma judgment in 2011, when Justice Katzu legalized passive euthanasia, but only under the provisions of court. Certain safeguards were provided, and the statement talks more about it and said, we cannot rule out the possibility that unscrupulous persons, with the help of unscrupulous doctors, may fabricate material to show that it is a case of terminal illness with no chances of recovery, and patients may be pushed towards a comfort care pathway rather than the care pathway. It took another 7 years to have the common cause judgment. The judgment which legalized for the first time that the right to die with dignity is an intrinsic or an inseparable part of right to life and liberty, which is enshrined in Article 21 of the Constitution of India. The second important thing which it validated was Advance Directive, and it was considered as one of the most important things as a component of right to autonomy and right to personal determination. However, safeguards were established, and these safeguards were considered important, but the undermined part was the complexity which was required in taking these decisions. The first thing which was required was a complex judicial procedure. So, in case the request for an end-of-life decision comes from the family, or the medical team decides that the ongoing care of a person is futile, the first step is a constitution of an internal medical board. The internal medical board is expected to give their opinion. This opinion is then subsequently to be referred to a judicial magistrate first class, who would constitute an external medical board. This external medical board would give their opinion and pass on the opinion to the magistrate first class, who is supposed to then visit the hospital and decide whether the person can be shifted to a comfort care pathway. This is a tedious procedure. For a patient who's on life support intervention, where days and hours matter, where every day extra spent in the intensive care unit would mean a lot of money, this procedure would take months, and it's not practically implementable. And in case there's a conflict where any of the medical board does not feel that this patient is suitable for a comfort care pathway, the person or even the medical personnel only has one option. They can file a writ petition in the High Court under Article 226 of Constitution of India, which is not a simple task. Our judiciary too admits that this has been a very complex procedure, and there's been a recent court order where they've tried to simplify these procedural safeguards. The experience of the doctors, which was previously 20 years, has now been reduced to 5 years. If a person wants to execute an advance directive, there's no longer a need for a judicial magistrate. And the time interval which was given as per the common cause judgment in 2018, it said the decision needs to be taken in a minimum of maximum 15 days. Now it is proposed that this duration is now being reduced to 48 hours after the constitution of medical board. But this is still to formulate as a judgment. While these safeguards have been adopted by our honorable courts, the medical societies have been doing their part. The Indian Society of Critical Care Medicine, which is the supreme society as far as intensive care practice is concerned, they came up with an end-of-life care policy in 2014. The basic aim was that a patient who has a life-limiting illness, they should not continue to be subjected to life-prolonging treatments. They also felt that the care plan should be tapered in such a way that the patient does not suffer towards the end of the life. At the same time, safeguards were provided so that all these decisions need to be taken within the ethical framework, with the basic aim that the decisions are taken in the best interest of the patient and their families. While these care policies were being given, we also came up with a simple framework in the form of a checklist, which was suggested that if we follow these checklists, at least there would be a complete decision process, and the decisions can be taken more so in the form of an ethical framework. The recommendations about the safeguards were very simple. The first and foremost thing which somebody needs to be done is establishment of the terminal nature of the illness. One needs to be very clear that this patient classified the criteria of a terminally ill. The second most important thing is futility of care. One needs to be sure that the treatment being given would not be in the best interest of the patient. This is followed by an extensive discussion among the team members. We cannot go ahead with the discussion unless until all the stakeholders from the medical team are sure that the patient qualifies the terminally illness or the medical futility. The next step is to have this elaborate discussion with the family, all the stakeholders. Whenever you have these discussions, all the stakeholders should be involved, because what happens is, first there'll be one person who comes, you discuss everything, then there'll be another person who comes up. There has to be an elaborate discussion about the diagnosis, prognosis, why the treating team feels that this patient may be shifted to a comfort care pathway, or why the treating team feels why this patient does not qualify the criteria of a terminal illness. There has to be an extensive documentation about all the aspects that were discussed, and if a person does qualify a candidate to be shifted under a comfort care pathway, you need to have clear discussion about the fact that these discussions, you need to inform them about, we've put that as one of the checklists, that the patient and the relatives need to be informed about the legal position of our country as far as the end-of-life discussions are concerned. This is followed by the extensive second part of the page, which is only followed if the patient is shifted to this pathway, and there's a documented discussion about what is to be continued and what is not to be continued. All India Institute of Medical Sciences has come up with a guideline in 2020. This is an extensive guideline about the end-of-life care plans, and it has significant amount of enclosures. Very simple things like there has to be written documentation about why the treating feels that this patient, the care of this patient is futile. There are enclosures where a person can request for withdrawal of care. There are enclosures where the family can actually ask for withdrawal of treatment. They've also provided with a ratification, with the advisory committee who is expected to ratify the decision of the medical board whether a person may or may not be shifted to a comfort care pathway. Similarly, this is the example of the enclosures that have been formulated by All India Institute of Medical Sciences. It is increasingly being accepted that CPR should not be offered to all the patients who are admitted to the hospital. In fact, the Indian Council of Medical Research came up with a complete paper, a guideline in 2020, where they've had an elaborate algorithm which needs to be followed in case a patient would be considered to qualify for a do not allow resuscitation pathway. This algorithm again has elaborate pathway where we need to have a discussion among the family members, among the treating team, and then evaluation even as a second opinion if there is a confusion whether the patient actually qualify or does not qualify, shift to a comfort care pathway. I'll share not a very recent experience, but there was an elderly lady who was admitted in the ward, and in the middle of the night she suffered a cardiac arrest. Since I work in an ICU which is on the same floor, our team rushed there. She was resuscitated, she was intubated and shifted to our ICU. The family was informed about the decision, and when they came back to the ICU, they said that we were actually tormenting, the person said that we were tormenting his mother, and that we had taken a decision which was wrong, and that he had never wanted his mother to be put on life support intervention, but this was something which was never discussed and never documented in any of the papers. So the simple change that we've done since that incident is, this is part of our history and physical examination sheet. So when a patient is admitted to our ICU, we have two very simple questions which are asked to the family and the patient. If the patient is competent enough, we ask them, do you have any advance directives? And if the patient is incompetent, we ask a very simple question. Does the family have any reservations about any treatment interventions? We mark it as yes and no at the time of admission. This is another area of significant debate. Some of you may be aware about the controversy with which Dr. William Hassel had to face. He was tried on 14 counts of murder. His job was to do terminal extubation. So they were terminally ill patients. The families had decided that this patient, they wouldn't want to continue with life support interventions. So when the endotracheal tube was supposed to be removed, there's a protocol where fentanyl or any other sedative is to be given. So what Dr. Hassel did was, he would give them about 200 times the dose which was required. His point of contention was that when a decision has been taken where the endotracheal tube is supposed to be removed, this means the patient is going to die. So why not ensure that the patient is as comfortable as possible? So he was finally acquitted by the court, but his license was withdrawn because the institution felt that the dosages that he was using were against the hospital protocols. There is another important thing which we all need to be aware about doctrine and double effect. The simple explanation of doctrine of double effect is that if you give, let's say you give a sedative like fentanyl or midazolam to a terminally ill patient, this is going to cause respiratory depression. So the doctrine of double effect says that if an act is done in good faith and it results in a negative outcome, that would not be considered as an offense. This is my second last slide. The Dutch law is supposed to be a frontier as far as the euthanasia laws are concerned. And the euthanasia was legalized in Dutch in 2020. And the basic reason why this nation is progressive as far as good death is concerned is that the government, the judiciary and the professional regulatory bodies, they are on the same page. The clinicians, they have been given the power to withdraw care, but at the same time they have devised review committees. The records would always be open to audit. And this is the reason this country has maximum number of dignified deaths happening. And this is my last slide. I think we need to have faith in our judiciary. But again, we need to understand things from the perspective of other stakeholders also. We need to have more awareness about advance directives. Since the common cause judgments, we've had very limited people who've executed in advance directives. If you look at it from the perspective of the families, every additional day spent in the ICU means a lot of money as far as a private hospital is concerned. From the perspective of a medical practitioner, we are caught between our principle of medical ethics versus the fear of judiciary. So even if I would wish to take a decision, I would be fearful of law. So this simply means, so at the end of the day, the person suffering is the patient and their families. So we need to have further simplification in the procedural safeguards that are being advocated. And last and most important thing is, in our country we have good acute care, but there's nothing beyond acute care. And if a person is given the option that he can live another day without pain, he wouldn't want to opt for euthanasia. So what is important is that we need to actually improve our rehab care. If end-of-life care would be good, there will be very few people who would actually want euthanasia to be opted. Thank you so much.